Hello, everyone. Yes, welcome again to our discussion. Today we will be discussing the form of contracts, that is Article 1356 to Article 1358. Yes, medyo maliit lang. So, kaya na-try natin i-insert siya sa schedule natin. Anyway, we will try to upload soonest possible time doon naman sa next topic, which is the, I think, interpretation of contracts or baka reformation of contracts. So, wag na nating patagalin. Let's begin. Article 1356. Contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for their validity are present. However, when the law requires that a contract be in some form in order that it may be valid or enforceable, or that a contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the rights of the parties stated in the following article cannot be exercised. Okay, so form of contracts. When you say form of contracts, is it necessary ba na in writing or pwede bang verbal or oral lang? Or dapat pa in case it is in writing, kailangan bang public document o pwede rin naman nasa private document lang, okay? So, as a general rule, as makikita mo naman in the first sentence ng Article 1356, contracts shall be obligatory in whatever form they may have been entered into. So, meaning, generally, form is not required. Okay? Hindi naman talaga kailangan yung form in order for a contract to be valid and obligatory. So long daw as yung tatlong essential requisites for the validity of the contracts, di ba? Consent, cause, tsaka yung object of contracts. Pag present naman yun, general rule, okay na siya. Obligatory at tsaka enforceable na talaga yung contracts. However, may nakalagay din karugtong, di ba? When the law requires that a contract be in some form in order that it may be valid or enforceable, or that the contract be proved in a certain way, so yung requirements na daw na yun is absolute and indispensable. So, yun, pag na-require ng batas, na dapat nag-require ang batas ng specific form para maging valid or di kaya para maging enforceable ang isang kontrata, then that requirement now is indispensable and absolute. Okay? So, kailan ba ni-require ng batas ang form para sa contract? So, form may be important. Meron tayong tatlong instances. Una, if yung form is important for or required for validity. Second, for enforceability. And third, for convenience. So, etong sa for validity, this is true in formal or solemn contracts. Okay? Ito yung mga contracts kung saan yung batas mismo ay ni-require or nag-require na ng specific form para maging valid ang contract. Kasi kung hindi, yung kontrata na yun ay walang epekto, walang legal effect. So, example dito talaga is yung donation of real property. Kasi kailangan, it must be in a public instrument in order to be valid. Makikita natin yan under Article 749 ng Civil Code. Another is under Article 748. Sabi naman, yung donation of personal property, pag yung value daw nag-exceeds ng 5,000 pesos, dapat donation and acceptance must be in writing. So, dapat naka-in writing. Tapos, another example is yung sale of land through an agent. Sabi, dapat yung authority of the agent must be in writing. Okay? And then, fourth, yung stipulation to pay interest. Dapat yung interest ay it must be in writing. Kasi kung wala, di wala ding interest. Hindi mo mai-enforce yung interest. Dahil yung batas mismo nag-require na yung interest ay dapat must be in writing. That is in under Article 1956. Okay? So, yan. Marami pa namang ibang example. Hindi to exclusive yung binigay natin examples today. Pero yan yung mga halimbawa kung saan ang form ng contract is required for its validity. Now, let's proceed dito sa second. Yung form ng contract is required for enforceability. So, ito yung actually, the best example for this is yung mga agreements na enumerate under the statute of frauds, which we will be discussing pag dumating na tayo sa defective contracts na discussion. So, actually, unenforceable contracts is under Article 1403. Madi-discuss natin siya in our next videos. Okay? So, another instances kung kailan yung form is important, sabi is, if yung form is required for convenience. Okay? So, eto talaga is if pag yung batas nag-require siya ng certain form para maging effective yung rights against third persons, okay? But as between the parties, hindi na actually kailangan kasi the law allows them to compel each other to put it in the proper form, okay? So, again, to repeat, general rule, hindi kailangan ng form of contracts kasi general rule, contracts are obligatory in whatever form they may have been entered into. Yung exceptions dito is when the law requires a certain form for first, its validity or for its enforceability, and lastly, for convenience. For now, let's proceed with Article 1357. If the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may compel each other to observe that form once the contract has been perfected. This right may be exercised simultaneously with the action upon the contract. Okay, obviously, this provision talks about yung right ng isang party to compel the other party to execute that necessary form. Okay? But note that this provision is actually applicable doon sa mga contracts wherein yung form is needed only for convenience. Okay? Hindi for validity or enforceability. Kasi pag kailangan siya for validity or enforceability, meaning pala, yung status ng contract na yan is hindi pa valid at hindi pa enforceable. So, dito si Article 1357, it presupposes na perfected or valid na yung contract and that it is actually enforceable. So, kumbaga, yung problema lang talaga is that kailangan ng specific form para sa convenience. At dahil for convenience lang naman siya, then the one party can actually compel the other party to execute kung ano man yung required na form ng contracts. Okay? At saka, if naalala nyo kanina, di ba sabi nga, if yung contracts, sabi ni Article 1356 na if yung contracts is if the law requires that such contract be in a specific form para maging valid or enforceable, di ba sabi the requirement is absolute and indispensable. So, yun. So, hindi talaga. This article, Article 1357, really talks about yung sa third requirements na for convenience lang. Okay? So, let's take an example. Example. if si Pogi nag-donate siya ng lupa to Ganda in a private instrument. Now, etong si Ganda, inaccept niya in the same private instrument na rin. Now, later on, gusto nang i-register ni Ganda ang donation. However, yung registration requires that donation be in a public instrument. So, etong si Ganda, nag-request ulit siya kay Pogi to put down the donation in a public instrument. Pero si Pogi ayaw na, okay? Pogi refuses to execute the public instrument. So, etong si Ganda, he then filed a case against Pogi to compel Pogi to observe the necessary form. So, question, pwede ba? Well, the answer is that hindi pwede kasi yung contract of donation, sabi ko nga kanina, siya is yung isang example kung saan the law requires that it must be in a public instrument para maging valid. So, yung donation actually is not valid. And since, sabi ko, Article 1357 presupposes na dapat yung contract is perfected and is valid at tapos enforceable siya. So, since hindi naman valid talaga on the first place yung contract of donation na in-execute nilang dalawa kasi nasa private instrument lang siya, then hindi pwedeng makompel ni Ganda si Pogi to observe or to execute the necessary form para ma-register niya ang donation. Okay? Pero if yung nangyari is ganito, suppose, si Pogi, binenta niya kay Ganda ang kanyang lupa in a private instrument. Now, later, nung gusto nang i-register ni Ganda ang sale, but alam niyo naman, registration requires public instrument. And so, question, may Ganda compel Pogi to execute the needed public instrument? So, the answer is yes. Because the contract, yung deed of sale is both valid and enforceable under the statute of frauds. Okay? So, since valid and enforceable naman yung contract of sale na ginawa nila in a private instrument, so pwede namang i-compel ni Ganda si Pogi to execute that necessary form. So, meaning, to put it in a public instrument para ma-register ni Ganda ang sale. So, that's it. That's Article 1357. Let's proceed with Article 1358. Yung Article 1358 naman, enumerate, sabi pa nga, the following must appear in a public instrument or document. Pero this provision is for convenience pa rin, okay? The necessity for the public document in the contracts enumerated dito sa kay Article 1358 is only for convenience, hindi pa rin for validity or enforceability. First, yung acts and contracts daw which have yung kung saan yung object is yung creation, transmission, modification, or extinguishment ng real rights, kailangan nasa public document for convenience. So, yung example natin kanina is, di ba, naka-private instrument yun, valid and enforceable. So, kailangan lang mag-execute ng necessary forms para ma-registered. Now, let's proceed with the second enumeration. Sabi pa, cession, repudiation, or renunciation of hereditary rights or of those of the partnership of gains. Okay? Sa mga hereditary rights naman. So, example, if si Pogi and si Ganda are heirs of, say, father, okay? Nung namatay si father, si Ganda and si Pogi, ang kanilang magkapatid sila, then they are the heirs of father. Since etong si Pogi, stable na rin naman financially, and nakikita niyang naghihirap si Ganda, nirenounce niya ang kanyang share sa inheritance from their father. And so, kailangan, for convenience, dapat yung renunciation must appear in a public instrument. Yun yung ibig sabihin ni Article 1358 dito sa number 2 enumeration. Now, sa number 3, okay, third scenario is in case naman sa power to administer property or any other power which has for its object an act appearing or which should appear in a public or document or should prejudice a third person. So, ito is in case, yun nga, power to administer property. Example naman is if si Pogi gustong magbakasyon and so gusto niya si Ganda ang mag-administer ng kanyang or mag-manage ng kanyang property and so he appoints Ganda to manage his property. So in this case, sa example na to, kailangan yung authority ni Ganda to administer the property of Pogi, kailangan naka-public document. Okay? And yung last case na in-enumerate ni Article 1358 is in case daw pag recession of actions or rights proceeding from an act appearing in a public document. Cession of actions or rights. So, example, if si Pogi minortgage niya ang kanyang lupa to Ganda para ma-secure ang kanyang, yun nga, may utang siya kay Ganda and so as a security for that loan, minortgage niya ang kanyang property in favor of Ganda. Now, etong mortgage was put into a public instrument or document, okay? It appears in a public document. Ang sabi ni number 4, yung cession of actions or rights proceeding from an act appearing in a public document must also be in a public document. So, dito, yung cession by Ganda of his right as a mortgagee, if ever, must also be in a public document, okay? Kasi yung rights niya, yung mortgage, appears in a public document. So, yon yung cession of actions or rights proceeding from an act appearing in a public document. Okay? Now, yung last paragraph, sabi, all other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. Pero yung sales daw ng goods, chattels, or things in actions are governed by Article 1403. Ito yung sa Statute of Frauds or yung sa unenforceable contracts. So, tandaan lang, all other contracts where the amount exceeds 500 pesos, dapat it must also appear in writing, kahit pa daw private one. Pero for convenience lang, no ha, hindi siya for validity or enforceability. So, bakit kailangan nga ba? Bakit kailangan must appear in public instrument? Yun nga, for convenience of the contracting parties and of course, for purposes of making it effective dun naman sa mga third persons kasi as between the parties, valid and enforceable naman talaga to. And to bind or to make it effective as to third persons, yung hindi parties sa contracts nila, then, yan, mas maganda it must also be put in a public document. Okay? So, that's it. So, thank you for watching until this far. Salamat